The U.S. Department of State designated Hamas a terrorist group. Hamas engages in terrorism, it relies on terrorism, and they get billions in dollars in aid from supporters around the world. It's a lot. Today, we witness a historic win as unshakable responsibility to join the call for mass mobilization. Okay, so go support Hamas, a designated terrorist group. That's a problem. The court must address whether plaintiffs, the Israeli plaintiffs, have alleged sufficient facts and legal basis to hold these defendants liable for the acts of terrorism. A battle now decided. This one involving a group of Jewish advocacy individuals and organizations versus a group of Muslim advocacy individuals and Palestinian advocates battling it out in the Eastern District of Virginia. Now we've got a new order that's come down from the judge saying how this whole case is going to go. But here's the background. They said, we are the plaintiffs. We're Maya, Aiden, Noach, Natalie, David, and a bunch of others. We're going to call ourselves, they call themselves, the Israeli plaintiffs. Okay, so it's not me calling them that, they're calling themselves that. Sue defendants, the Muslims for Palestine and national students. I guess we can call it the Israelis and the Muslims, or the Palestinians. Here's their introduction in this lawsuit. When someone tells you that they're aiding and abetting terrorists, believe them. They say Hamas is a terrorist organization, and they're trying to prevent Israel from maintaining relationships with its Arab neighbors. And so a lot of background. Now we get to the organization. They say American Muslims for Palestine serves as Hamas's propaganda division in the United States. Now we're asking about free speech, right? Propaganda. Can American Muslims speak about these issues, or is that Hamas propaganda that makes them a terrorist organization in America that subjects them to a lawsuit? AMP was founded from the ashes of disbanded organizations created by other Hamas officials, and the day after, on October 8th, they were prepared to respond to a call for mobilization and disseminated a manifesto, and they created a toolkit, and they support globalizing attacks on Jews. And so the plaintiffs are U.S. citizens. Her name is Miss Parazer, and her boyfriend. They survived the Hamas terrorist attack. They dodged gunfire, and they weaved through dead bodies on the roads. And so they suffer mental anguish because they're providing material support, these other groups, to Hamas, right? So we're suing you for that. Plaintiff, another one, Mr. Guess, is a U.S. citizen. On 10/7, his home on Kibbutz Holit was attacked. While Guess was not home, through a communal WhatsApp group chat, he witnessed friends and family members brutally murdered, and he's suffering from this. So same here. Mr. Newman, he was there. This person's a U.S. citizen. She survived. Mr. Diller, also a U.S. citizen, was over there, survived Hamas, and the rest of them. Okay, so we get the story. Now, the defendants, this is called AJP Educational Foundation. It's another 501c3. It's another nonprofit incorporated in California, doing the same thing as Norm Eisen does, Democracy Docket does, the National Jewish Advocacy Center. Okay, they formed their 501c3s, and now they're just suing each other. So everybody forms their little 501c3s for their cause du jour, and for some reason, our society and our courts just allows everybody to come take advantage of them and duke out their 1,000-year-old conflicts in our courts, and we got to be able to deal with it. So in a separate action, AMP is accused of being the successor to two other organizations and dodging a default judgment. And so this is another defendant, the National Students for Justice in Palestine. They say that they're using this to operate a propaganda machine on college campuses, and they need to be stopped. Okay, so we get the complaint. Here is what the judge said. In a ruling, memorandum opinion and order from the judge in the case of the Israeli plaintiffs versus the Muslim organizations, the judge writes, all right, this matter comes before us because the Muslims have filed a motion to dismiss, a bunch of them. Bazian, they sued a bunch of people individually. Osama, we've got Tahir, Zarefa, and others. The court has dispensed with oral argument as I don't need to hear from you people. Shout out to this judge. I'm just going to rule on your pleadings. I don't need to hear you guys scream about this for 6 hours. These matters have been fully briefed and are now ripe for disposition. And so considering all of this together and the parties' filings, the court grants the motions to dismiss. So the Jewish lawsuit fails. Plaintiffs, Maya, Aiden, and the others, they call themselves the Israeli plaintiffs. They bring this 2-count action against the Muslims. They say the Muslim student organizations have aided and abetted Hamas. And that's a violation of the Anti-Terrorism Act. The amended complaint says there's a history of material support for them, and there's a series of events, and they just keep supporting them. So here's what the judge says. On October 8th, 1997, the U.S. Department of State designated Hamas a terrorist group. Hamas engages in terrorism, it relies on terrorism, and they get billions in dollars in aid from supporters around the world. It's a lot. In 1988, Hamas and the Muslim Brotherhood founded the Palestinian Committee, a small network of organizations to serve Hamas. In 1993, the FBI wiretapped a meeting between the Palestine Committee and Hamas operatives. The meeting revealed that the Palestine Committee directly coordinated with Hamas to help achieve its goals. Okay, so we've got now cooperating cooperation with terrorists documented, as meeting participants discussed how to improve the activities in support of Hamas and how to shield them from being designated a terrorist organization. Now, the organizations that made up the Palestine Committee included here these other groups: the Holy Land Foundation, the Islamic Association for Palestine, the IAP, the American Muslim Society, all these groups, okay, gobs of them. For instance, Khalid Mashal, the former head of Hamas's political bureau and current leader of Hamas's diaspora office, founded the IAP. So lots of overlap too. Now, HLF and IFP, their fundraising for and in collaboration with Hamas was eventually discovered, and they were found criminally and civilly liable for providing material support to Hamas, like these people or these organizations and the individuals related to those organizations. In 2001, this was designated HLF a specially designated global terrorist. 5 of its leaders were convicted of providing material support to Hamas. These other people were found civilly liable of supporting terrorists, and these groups subsequently dissolved. The amended complaint asserts that the creation and dissolution of these organizations has become a pattern. So the Israeli plaintiffs say that this charitable group was founded by Hamas and the Muslim Brotherhood and subsequently dissolved following the settlement period, and more. Now, the complaint continues. They say, well, what's happening here is they're resurrecting these groups. There was an original enterprise that got dissolved. Now there's significant overlap between these groups, and they are committing effective propaganda saying, well, this core leadership, they were part of the other group and part of the other group. Now, here they give us the connections. Okay, Rafiq now serves as a tax preparer. This guy previously worked as a secretary general. Like, they just left one organization and they all came over here, and the judge is articulating it all right here. Yeah, it's true. He collaborated with them. Finally, this guy, a former active member, chaired the convention, right? The judge is saying there's all sorts of connections here. You're right. There's overlap out the wazoo. So the Israeli plaintiffs say that AMP is effectively a reincarnation of this, and they're just changing their goals, kind of like Hunter Biden, creating all his shell companies. Says AMP has become more cunning and purposeful in their efforts, and they've made themselves into a mouthpiece for Hamas. It says that the defendants here and all their social activity are supporting and propagandizing Hamas. The judge is giving us a lot of details, and we've got, of course, the terrorist attack. On 10/7, the deadliest single day for the Jewish people since the Holocaust, Hamas terrorists killed approximately 1,200 Israelis, Americans, and many others in a horrific day. The terrorists tortured, butchered, and is horrific. Plaintiffs were among the initial victims. They were forced to evacuate their homes. Within hours of the attack, the leader of Hamas called for resistance abroad. 3 days later, Mashal, the founder of IAP, called for global supporters of Hamas to, quote, be part of this battle. And he asserted that through a terror by propaganda strategy, Hamas was going to exploit the international community's response to civilian casualties, generate global condemnation of Israel, hamstring IDF operations, and protect Hamas under the guise of civilian safety. This strategy was employed to sway people, and this was the first wave of propaganda. Then the Israeli plaintiffs say there was a second wave of propaganda. Within hours, there was a disinformation campaign, and another defendant who's being sued here, they released their Day of Resistance Toolkit. And the toolkit says that the resistance has taken occupation soldiers hostage, fired thousands of rockets. Today we witness a historic win as unshakable responsibility to join the call for mass mobilization. Okay, so go support Hamas, a designated terrorist group. That's a problem. So the NSJP calls for its members and its allies not only to support, but to struggle alongside with our people back home and, get involved. The toolkit goes on, says it's part of this movement, and the Israelis say that neither Hamas nor any other terrorist organizations had ever used paragliders until this day. They also say they endorse this statement, the Tofan al-Aqsa statement, talking about victory or martyrdom and an intifada, right? And they're very aggressive with it. Now, the amended complaint says the toolkit is an action-oriented memo, and they're engaging in public relations services. The crux of their complaint is this, that the defendants fund and act as Hamas's public relations division, and so they're suing to stop them. They say that they organized a day of resistance to coincide with a day of rage, and that they're terrorizing students at all these universities. They say that they're continuing to provide ongoing public relations and support. Now, here's the procedural background. We are now dealing with motions to dismiss this lawsuit. The rules say you have to state a claim. You may attack the complaint on its face when it fails to allege facts saying that I have jurisdiction over this case at all. And there are different standards here as well about personal jurisdiction. But let's see how the judge applies it in his analysis. We've got the rules out of the way. He says, okay, as an initial matter, this court recognizes that what happens to plaintiffs in the October 7th attacks was horrific, no doubt. And that should be undisputed. Get that out of the way. Unequivocally true. Yet that is not the question before the court. The court must address whether plaintiffs, the Israeli plaintiffs, have alleged sufficient facts and legal basis to hold these defendants liable for the acts of terrorism. Now, at this stage, the court cannot find that the Israeli plaintiffs have met their burden, and so case dismissed. But it may be that they can further amend their complaint to assert more particularized facts, okay, not conjecture, not speculation, that is an actual claim. Although the court dismisses the complaint, will allow you to refile, which they probably will. A full discussion of the arguments is below. Here's what the judge rates. The court has pending before it 7 motions advancing various jurisdictional merits. Now, the defendants, all, these Muslim groups, argue that this court lacks jurisdiction over them. All the defendants say this court lacks jurisdiction because they're filing under the Terrorism Act, and they lack standing. And so the judge is going to go through each of them in turn. He says the plaintiffs assert their claims under the Terrorist Act, which has a nationwide service of process provision that authorizes jurisdiction. And we correctly note that service of process provides jurisdiction, and so lots of legalities here. Now, to begin with, each defendant challenging personal jurisdiction has minimum contact with the United States. In fact, this guy lives and works in California and works as a liaison, and so that's fine. The court must then determine whether challenging jurisdiction is properly allowed under the Terrorist Act. And they don't argue that service was effective. Now, he next argues that leaving the summons, so they just came and when they got sued, they just threw the complaint at his wife. He says, that's not service of me. You have to serve me. My wife's not being sued. So we're, fighting over service. Okay. Now, with respect to the Israeli plaintiffs and their terrorist claims, the defendants say that service of process does not apply and the court lacks jurisdiction. Writing, here, it's clear that these claims arise from a common nucleus of operative facts that apply to both claims. They're saying it's related to the 10/7 attacks. And so the court will exercise its discretion to consider this claim. Next, we want to talk about subject matter jurisdiction over the plaintiffs' ATS claims. Here, it's important to frame their injuries when and where they occurred. The injuries occurred in Israel on October 7, 2023. Thus, in examining their claim, we must analyze whether the conduct is meant to be governed. Here, because their injuries occurred on 10/7, the court must examine their allegations about their conduct in the United States before that occurred in Israel. And it's clear from even a cursory review that the plaintiffs focus on not what they did in relation to 10/7, but they're only complaining about what they did after the attack. And by contrast, allegations about this say that they were supporting them prior to the 10/7 attacks is very limited. Specifically, in the allegations about their conduct, they say that the defendants provide ongoing support to Hamas and their mouthpiece after. Okay, it's all after the fact. So how did they aid and abet Hamas to commit the terrorist attack? They're not even alleging that. They don't even allege that they planned, prepared, funded, or anything. And so these public relations allegations are just vague and conclusory, and they can't satisfy your burden that there's a significant or sufficient connection between your cause of action and the damages that you're seeking. Now, your amended complaint focuses on stuff that happened after 10/7, and that could not have assisted with the initial attack. In fact, the Israeli plaintiffs do not even allege sufficient facts to plausibly show that the defendants had prior knowledge of the attacks. And so the court finds that this inference is not reasonable and declines to draw an inference, which was that they asked this court to say that all defendants knew about the attack because they responded to the attack, which had a clip art style graphic of a paraglider. So their immediate response had a paraglider. They're like, oh, how they know it's paraglider? Like nobody knew it's paraglider. So they knew they were part of it. So they argue that there was coordination between these groups and Hamas, and they reference international law. But in short, even though they allege domestic conduct, almost all of their allegations relate to after 10/7. They fail to show how any of this domestic conduct is relevant, how they assisted on 10/7. And unlike in other cases, including the execution of a contract, we need to know what is the actual harm and sufficiently connect the two. Here, they failed to establish such a link, and so the court lacks jurisdiction. And so in the absence of this factual link, we have to dismiss the claim. Because their allegations about public relations activity fails, the other claims must fail. And so in summation, the judge writes, the cases and the claims will be dismissed. In sum, while the court has personal jurisdiction over the defendants, it lacks subject matter over the claims. Moreover, they failed to state a claim under the ATA, and so for the foregoing reasons, all of these motions to dismiss are granted. Without prejudice, they can file a second amended complaint. I'm sure they will, but Rossi D. Alston dismissing this case, saying, you got to have some more concrete claims. You can't just be suing everybody, saying that you're propaganda pieces for each other, because I'm sure the Palestinians could just return back and just say, you're propagandizing for the Israeli government or whatever. And everybody can make those claims, of course, pointing to different facets, but that's what we've got on that one. So we'll see if a secondary complaint comes in. I expect that it will, and we'll keep our eye on this one and more.